Mr. Deputy Speaker, I would like to declare my interest as a disputes lawyer in private practice. In last year's budget, SMEs were described in some materials published by MOF as being at the heart of Singapore's economy. They make up 99% of our enterprises, employ 2/3 of our workforce, and account for half of Singapore's GDP. This is a positive sign which demonstrates the entrepreneurial spirit of Singapore. The 2017 annual business survey conducted by Singapore Chinese Chamber of Commerce and Industry found that business sentiment among Singapore SMEs has risen. However, SMEs continue to face a number of challenges. The same business survey also revealed that SMEs continue to face rising business costs, with 72.3% of respondents saying that they face higher business costs compared with 62.3% the year before. Rising business costs is also cited as the biggest challenge by 68.4% of those polled, ranking ahead of competition in the Singapore market and manpower shortage. The government continues to help SMEs through various means, for example, through the SME working capital, and we just heard today's debate on Enterprise Singapore Board Bill to support enterprise development, yet another example of helping SMEs. SMEs themselves would have to continually evolve ways to deliver more productivity gains, for example, by leveraging on technology. One area that we could look closer at and where small businesses are particularly disadvantaged is in respect of contractual dealings with large suppliers who dominate the market. These dominant players' usage of market power to drive the use of one-sided and unfair terms has the effect of increasing business risks and costs on the part of small businesses. I respectfully suggest that the time has come for regulatory and legislative solutions to be offered to protect the interests of small businesses from such domineering practices. Mr. Deputy Speaker, sir, to provide members of this House a better sense of the clauses I'm referring to, I seek leave to distribute to members a handout containing some standard clauses that are incorporated in the areas of provision of utilities, telecommunication services, and leases.
Leave is granted.
I'm grateful, sir. I'll be referring to these clauses in the body of my speech. In the budget debate last year, I raised the issue of large players taking advantage of their size in commercial dealings with small businesses. This persists in the rental markets, which involved, on the one hand, landlords with muscle, such as REITs, and on the other hand, tenants which are small businesses. This imbalance in power has allowed tenancies agreements to contain onerous clauses for tenants. For example, a demolition clause allows the landlord to recover the premises for redevelopment purposes initiated by the landlord itself without any compensation to the tenant, who may have spent a significant sum to retrofit premises and who may not have had the benefit of most of the term of the tenancy. An example of such a clause may be found in the handout. I dealt with such a case some years back. I acted for my aunt, who ran a beauty parlor at a shopping mall for an initial period of 3 years. The mall owner extended her lease for another 3 years. My aunt decided to spend money to renovate her premises. About 10 months later, she was served with a notice to yield premises on the basis that the owner decided to renovate the floor in which her beauty parlor was located. My aunt was in tears as she had plowed most of her savings into renovating the premises. She was facing a certain financial ruin. Not only that, she was upset that her staff, who had been loyal and been with her for years, would have to be let go too. Thankfully for my aunt, the High Court, in a reported decision, ruled that the owners exercised demolition clause in bad faith. This is rare. For the vast majority of tenants in my aunt's shoes, they have to yield their premises without any compensation. Additionally, commercial lease contracts include provisions stating that the tenant is responsible for any additional property tax that is payable on the leased premises above the base property tax payable by the landlord. However, if the shoe was on the other foot and the landlord subsequently receives tax savings through tax rebates, reliefs, or exemptions, there's no contractual provision requiring the landlord to pass this tax savings to the tenant. It's also common for commercial leases to contain what I term as illusory options. What do I mean by this? There are leases that provide that options to renew are granted on the basis of rent to be decided by the landlord at the time of the renewal. Another variation is the provision in the leases that the revised rent is to be determined by the landlord, whose determination is final and conclusive. In both cases, the contractual provision giving the tenant the right of an option to renew is effectively illusory and non-enforceable, as the essential terms for the renewed lease have not been agreed on, and the tenant can potentially be provided with a Hobson's choice by the landlord at the point of renewal. It's unfortunate that despite Singapore Business Federation's laudable attempt to address this situation by issuing the Fair Tenancy Framework that was put together by its Rental Practices Working Group, chaired by Ms. Cynthia Phua, a former parliamentarian, in 2015, the usage of these onerous clauses still subsists. Besides tenancy contracts, other examples of contracts which may contain unfair clauses include contracts for the provision of utilities or telecommunication services. I've provided illustration of such clauses in the same handout that I distributed earlier in the House. For such contracts, small businesses are often in no better position than individual consumers in that they have little bargaining power to negotiate contract on the supplier's standard terms. Presently, in Singapore, small businesses are given some protection when entering into standard form contracts under the ACTA, or Unfair Contract Terms Act. However, ACTA protections focus mainly on certain types of clauses, such as exclusion of liability clauses and indemnity clauses, which must be reasonable in order to be enforceable. Even then, certain types of contracts are excluded from ACTA, such as contracts that involve property interests. In a report for the Federation of Small Businesses written by the Centre for Competition Policy in the UK in 2014, the report recognized two key arguments in favor of providing greater protection for small businesses. The first is that small businesses who may not be as sophisticated and have the same level of resources as large companies need protection to make effective purchasing decisions relative to larger businesses. Second, as a matter of policy coherence, if small businesses behave more like individual consumers than they behave like large businesses, then it would be coherent to treat them the same under the law. In Hong Kong, small businesses may rely on the Control of Exemption Clauses Ordinance, which is the equivalent of our ACTA. However, unlike Singapore, for consumers, which by definition excludes small businesses, there's also recourse to the Hong Kong Unconscionable Contracts Ordinance. The UCO provides that with respect to contract for sale of goods or supply of services in which one party deals as a consumer, where the court finds any part of the contract to have been unconscionable in the circumstances when the contract was made, the court may refuse to enforce that part of the contract or limit the application of the unconscionable part. The Hong Kong UCO vis-à-vis consumers is therefore wider in its application compared to Singapore's ACTA, in that it applies to all contractual clauses and not merely exclusion or indemnity clauses. The Hong Kong UCO was modeled after the Australian Trading Practices Act of 1974, which applied to both small businesses and consumers. USA and Germany have also legal provisions that render one-sided contracts with small businesses unenforceable. Article 138 of the German Civil Code, known as BGB, renders a legal transaction where a person exploiting the counterparty's weakness grants to himself a pecuniary advantage which exceeds the value of performance to such an extent that under the circumstances, the pecuniary advantages are in obvious disproportion to the performance void. Section 2-302, subsection 1 of the Uniform Commercial Code of United States provide that if a court, as a matter of law, finds a sale contract or any clause of a sale contract to have been unconscionable at the time it was made, the court may refuse to enforce the contract, amongst other options. This provision has been judicially interpreted to apply outside the arena of sale contracts to lease of chattels, insurance contracts, and other areas. Perhaps Singapore could consider similar legislation. The current UK position is similar to Singapore's in that only legislative protection afforded to small business is through the UK ACTA. The main tranches of consumer law, such as the Consumer Rights Act 2015, which offer the most significant protections, only cover individual consumers. However, there's some sectoral protection of small business customers in the UK by the regulators. For example, under the 2003 Communications Act, a distinction is drawn between domestic and small business customers and other customers. Consistent with this, the UK telecommunications regulator, Ofcom, provides such small businesses with the same protection as domestic customers throughout its general conditions. For example, both types of customers are covered by Ofcom rules relating to information to be provided at the point of sale, the ban on automatic rollover contracts, and restriction on misleading or aggressive selling. Each supplier is required to develop and publish a code of practice for both individual and small business consumers that should, at a minimum, specify where such customers can avail themselves of necessary information. Access to alternative dispute resolution scheme is also available for both domestic and small business customers. Australia has taken a robust approach to protecting small businesses through the Competition and Consumer Act 2010 and the Australian Consumer Law, or ACL. The ACL provides for a national unfair contract terms law covering standard form consumer and small business contracts. The ACL provides that a term is unfair when it causes a significant imbalance in the parties' rights and obligations arising under the contract, and it's not reasonably necessary to protect the legitimate interests of the supplier, and it would cause financial or non-financial detriment to a party. Terms that are determined by a court to be unfair are void. Additionally, the Competition and Consumer Act and the ACL are administered by the Australian Competition and Consumer Commission, which may investigate alleged breaches of the Act and take enforcement or compliance action. Apart from this, certain Australian states have also enacted additional laws for more sectoral-based regulations. For example, in Western Australia, most retail shop leases are regulated by the Commercial Tenancy Retail Shops Agreement Act 1985, which do not apply to leases to publicly listed companies and which regulates commercial tenancy agreements. For example, the Act prohibits the landlord from engaging in conduct that is unconscionable in connection with the lease. The relevant factors to be taken into consideration to determine whether the landlord has contravened this section include the relative strengths of the bargaining positions of the landlord and tenant, whether the tenant was required to comply with conditions that were not reasonably necessary for the protection of the legitimate interests of the landlord, and whether any unfair tactics were used against the tenant. Having regard to the approach taken by other countries, I personally prefer that we examine whether there is a need for a general protection approach, such as that provided by the Australian ACL, instead of a sectoral approach. This will be consistent with instilling principles of fair dealing in corporate cultures where customers are able to have the confidence that they deal with companies where fair dealing is central to the corporate culture. Such a fair dealing guideline has already been implemented in 2013 by the Monetary Authority of Singapore in the financial industry in Singapore in respect of financial institutions and their customers. It is open for other regulators in Singapore, such as IMDA or EMA, to adopt MAS's practice and require the big players to provide fair dealing outcomes to their customers. Providing legislative and regulatory protection for small businesses would go a long way to equalize the bargaining positions between small and large businesses and lower the business risks and costs assumed by these small businesses. It will make them more competitive and hopefully allow them to make an even bigger contribution to the vibrancy of Singapore's economy. Thank you.